rise. The Honorable Judge Rivera, preside.
Thank you, may be seated. Let's see, we just have one set of cases. Michael David Barksdale.
Yes, ma'am.
Mr. Barksdale, we're here for motions, is that right, Ms. Gonzalez?
Evidently,
Okay, any motions filed?
he's got a motion filed, we don't have it.
Okay, and I guess there's a copy of it in the system. Let me get to that. Sorry for the tardiness. They've scheduled me here and there and back and forth. I got my schedule confused.
Want me to transfer you? For you to see it?
Oh, sure, yes, that'd be great. I didn't even see them.
Could you hand that to the judge as a copy of the motion?
Is that a spare copy?
Yes, ma'am.
Okay, great. It's printed. Okay, too bad. We can't stop it. Give me just a few minutes to review it.
Yes, ma'am.
Okay. Let me see if I understand. Look one thing up before we begin. Okay, you may proceed to explain your motion, to argue your motion.
Okay, well, I guess do I have to stand up or can I have a seat?
Yeah, you're the one who's filed the motion, so that you have the burden to convince me, I guess, to follow your request in the motion. Yes.
Okay, well, the charging, or the ticket, it's not checked hazard mat or commercial vehicle, so by default it is checked no. So I was not engaged in commercial activity, nor was I transporting hazardous material. So therefore, I'm not subject to the transportation code, since I was not engaged in commerce or transporting hazardous materials. That's pretty much what I guess I'm going to is in my motion. Just sum it up for me.
So your argument is that
I was not engaged in commercial activity.
that no person driving a vehicle in the state of Texas can be given a ticket unless they're engaged in commercial activity?
This is correct. There's no law that says that I can't drive my private or operate my private automobile at my leisure. Nowhere does it say that I cannot do that. But it does say that I cannot operate it if I'm engaged in commercial activity or if I'm transporting hazardous material. And since I have a right to travel according to chapter, let me see if I can do this. Natural Resource Code, chapter 114, the definition of public highway, so this will be judicial notice to the court, is open to the people as a matter of right. So if it's a right, I don't have to ask for permission to do it. Just like I don't have to ask for permission to breathe because it's a right that I have to breathe. So therefore I don't have to get a license to breathe. Same with travel. And it's enumerated in chapter 114 of the Natural Resource Code, which is where the court will take judicial notice of. Under the definition public highway, it's open as a matter of right.
And that is the center of your argument, is that correct?
Not in the motion, no. The center of my argument in the motion is that the charging instrument is flawed. That you have no valid charging instrument.
Okay, I missed that in the motion.
Well, right there where it says, court will take citation titled vehicle, the item called commercial vehicle is marked no. It's not that it's not marked no, it's that it's marked no by default since he did not fill it in. And I have a copy of it if you'd like to see
So
it.
you're taking the citation as the charging instrument as opposed to the complaint?
I haven't received a complaint, and I don't believe she has a complaint either.
I don't have one today.
And I'd like
He
that.
didn't request any documents.
Well, I don't have to request a copy of the complaint.
Okay. It is not clear to me from reading your motion that one of your charges or allegations is that the complaint is defective. Consequently, they wouldn't have been placed on notice to create one. I mean, the citation is not going to be the ultimate charging instrument, so there's no purpose in arguing the citation itself because so I'm not going to rule on that as it is not going to be. The charging instrument is not that.
It is not the ticket.
The charging instrument, when you go to trial, will be a complaint.
Okay, with the Texas Constitution that says you have to have an indictment or information to proceed, you can't proceed on a complaint.
To proceed on trial, we're here on motions, not on trial. You will have a charging instrument before you go to trial. Frankly, at the moment someone pleads not, the process here was to immediately create a complaint. Is that no? So is there a complaint? Because I can't get into the system.
No, it's a motions. There is no pleas on his cases. We went straight to a motion document.
I don't
How
know.
did that happen?
I don't know. There's no pleas on these three cases.
Okay, it should never have been placed on motions. You need to enter pleas on each of your cases today. You will have the opportunity right before you go to trial. This time before we go any further with your, we have to take things in a certain order, and I did not realize that that order had not been followed. Give me just a moment to get your cause numbers.
I don't think that's all of it, though. And there's more.
Barksdale, are you Michael David Barksdale, born July 24th, 1971?
I am, Your Honor.
And to the charge of expired registration on April 3rd, 2010 at Ocean Drive at Park Avenue, how do you plead?
I don't know if I want to plead.
Anytime a defendant refuses to plead or enter a plea, the court can enter a plea of not guilty for them.
Correct. Am I waiving anything when I enter a plea of not guilty?
No.
No? Well, then you...
Not that I can think of. No, I mean, no. You're waiving nothing. You still have your right to motions. You still have your right to trial, whether it's bench or jury. And
Okay, well, if I plead not guilty, then that means that the ticket stands? No?
no, once you plead not guilty, they create a complaint. And then, at that point, you get at least 3 days to have and review that complaint, and whatever notice time you need to be given a date to return for trial. Now, because this was set before you entered a plea, one of your reasons for this motion is not right. It's not ready. So we may end up having to have another motions hearing with regard to any allegations you may have as to the complaint being defective.
Do I need to enter a plea if I'm challenging the jurisdiction of the court itself?
Yes, yes. So,
Your
is that
Honor,
what-
Your Honor, for the record, my understanding this was a challenge to the jurisdiction. I don't see anything in his motion challenging the charging instrument, the complaint, or anything of the sort. So I don't think,
Well,
I guess
the
what I meant-
officer
for him to
became-
say that he was not presented with one, Your Honor, at this point is incorrect, because that was not my understanding of his motion. It's a little convoluted, so I'm not sure.
I'm equally confused. I guess my question is, from a motion that is here, I'm not understanding that you were challenging the jurisdiction of the court. Now, you can argue orally any motion. However, the state has a right to request a continuance to prepare a response. So if you have something new that has not been addressed in writing, then they have a right to hear what it is, prepare for it, and return if they're not ready on this date, because they had no sufficient notice or no due process on their part to proceed. So,
Okay, well, the way I'm challenging the jurisdiction is the officer lost jurisdiction after he became a trespasser ab initio, and that is in the motion. After he violated law, he became a trespasser from the very beginning, which means that they lose jurisdiction over the entire case.
I don't think his motion rises to that, Your Honor. There's absolutely no evidence to that. I don't even think that applies in this case. He was acting under the color of the law. His duties are to enforce the laws of the state of Texas, which is what he was doing. So he does not qualify as a trespasser.
Well, he may not be construed, officer was ignorant of the law. We cannot say that the officer is ignorant of the law. The officer must know the law at all times.
Okay. Again, that's not a basis to challenge the jurisdiction.
that is not a jurisdictional challenge. And I disagree with your argument that he had no jurisdiction because he was a criminal trespasser, because to believe that, I would have to believe or have some evidence that he was criminally trespassing. You're making allegations that he was criminally trespassing because he was violating the laws. I don't see which law he was violating. In this motion, I'm not seeing a law that was violated.
The law he violated was that he seized my automobile without a court order.
Okay.
And I do see that it's not in here. Yes, I do.
Again, Your Honor, it was according to the law. He had no insurance, did not provide any proof of it. That gave the officer the authority to
And
impound.
then I do need to study is
Right,
whether-
but you need a court order to take anybody's property, period. And if you don't have a judge directly ordering the court order, you cannot take their property.
You cited it, and I've read it a number of times in the past. Let me find it and reread it now.
I have Texas Constitution,
No,
Section
not the
9, searches and
Constitution.
seizures.
You know, the law that allows for the impoundment of the
And-
602.
It's the one that has to do with his financial responsibility. I don't have the
Right,
exact number.
622?
601.
601?
602,
Oh, 601.
I'm sorry, 601.261.
Oh, yeah, 601, 261, impoundment of vehicle. Oh, there's another violation of law, that the sheriff did not impound my motor vehicle, or my private automobile. Some wrecker company did. And I'm alleging that the officer and the wrecking company are in concert and collusion, are acting in concert and collusion to, you
Again,
know,
Your Honor, there's absolutely no proof of that.
there's no proof that the wrecker showed up and took my truck?
As to
I don't
the
know, I don't
concert
follow
and
that.
collusion.
I'm sorry?
As to the concert and collusion.
Well, the officer called the wrecking company, which is acting in concert and collusion with,
Hold on.
and only the
Hold on.
court shall order
Hold on
the
just a
sheriff.
second.
Hold on.
Cheater glasses. Who's got cheater glasses?
I don't have one. I have the law right here.
I have it right here as well.
You may try mine? I don't know what happened.
No, it's okay, I did okay. The court shall order. Okay, how do you get around 601.261, Mr. Zoll?
Objection? How do you get around, what does that mean?
How does she explain, how did she argue against your argument?
Okay.
Of
I thought you were trying to circumvent the law, I'm sorry. I
Your
didn't
Honor,
know.
my understanding is the officer had a right, a valid reason to issue the no financial responsibility ticket. And that particular law allows him, if, in fact, I don't know if this was the first time or not, Your Honor, but my understanding this is not the first time that he has received an issue.
No, I want you
This
to
is the
read the
first time
line.
I've been
Yeah,
over.
because I don't know, I'm reading here.
I don't have it,
and
I can go get it, Your Honor.
I need to subpoena
Hold on.
the order from the,
Despite
This is
that,
not a
I'm
discovery
so
motion, you
sorry.
haven't filed a discovery motion, we're gonna take turns one at a time.
Yes,
But
ma'am.
I'm gonna read aloud to you, and I know that there is an answer, and you as a prosecutor
I will
are
look
to
for
give me
it.
the answer. Here, under this section, he is correct. I believe there's another section which contravenes this, and that's, I will
and
look for it.
objection, and if there is a contradiction in between this one and another one, then this one stands, does it not? Because this is statute.
And the other is statute as well.
Well, then how can you have contradicting statutes?
Hold on. On a second or subsequent conviction for an offense under section 601.191, first, let's see if this is an offense under 601.191. Can you go get one of these? We have hundreds. We don't have any of the update ones on the benches, but they're similar with regards to these laws. We actually have some.
I will be subpoenaing the court order and the name of the judge that did order my car to be impounded.
Okay. Let me
So if you don't
explain-
have that-
Hold on just a second, Mr. Barksdale. Let's start over here. A motions hearing, we can't have 10 motions hearings for a single defendant. Okay, you will bankrupt the city with that. You need to be prepared and ready with everything at once. We can't
Is there
Do
a
you have
law
any
that says I
motion?
can't file 10 motions with it?
all at once. I mean, we can't have
But
10 hearings.
is there a law that says I cannot do that?
Your Honor, I think procedurally, there is a time frame within which he has to
Yes.
file
And-
those motions.
That's correct.
He can't just
To
continue.
file the motions, right, but
And-
not the amount of emotions, because that's what she just said, that I can't file 10 of them.
Yes, you can.
You can file
Okay,
10
okay,
and 11,
okay,
but
that's
But
we
not
can't-
at 10 different times.
We're not
Okay.
required to set 10 different hearings.
That's cool, that's all I wanted to know is that, I mean,
So
there's no
you-
limit on motions that I can
you-
file.
You have brought 3 or 4 motions that the state's not ready for, that the court hasn't had a chance to review papers on. You,
Your Honor, I'm sorry, but I realize that the court has questions on the impounding of the vehicle, but I still don't see how that relates to his motion. How that would
This
be
is-
challenging to the jurisdiction at all, Your Honor. I mean,
Right.
that would probably be a separate motion altogether, but I'm not going to tell him how to do his.
right. And that's,
I mean, I
that's part of the problem is, you know, it appears a good bit of law, but you aren't necessarily following the procedures that are required by the law.
I think I understand. I should have put all this inside the motion, then we could argue every point of it.
Right, so that they have sufficient notice to prepare and responses. And it makes for a cleaner resolution of each issue. But here, you know, they could argue that they're being sandbagged. You can just pass it to Ms.
Well,
Gonzalez.
as am I, because I have to be here, because I have a private automobile, and I wasn't engaged. This is a waste of my time, so.
Okay. Let me just put it this way. If your argument in today's motion is that no person in the state of Texas can receive or be given a traffic citation unless they are in commercial activity, let me ask you, is that your argument?
That's not all of my argument, but it is part of it, yes, ma'am.
Okay. That being part of your argument, I don't believe the law supports your position. The law allows the state of Texas issue and require persons to have a driver's license to drive, whether it's for commercial activity.
But I'm not a driver. Not according to Black's Law Dictionary. A driver is one employed in conducting a coach, carriage, wagon, or other vehicle. And I wasn't hired to move about that day. So I'm not a driver. You're gonna have to call me a traveler.
You can look up other words for employed. Employed can be.
Well, we're not
actually-
dealing with employers, we're dealing with a
No.
driver.
Read your definition from the beginning.
Oh, one employed.
It
Right.
doesn't
That
mean-
means for hire.
No. Employed can be who is doing. One person who is doing. It doesn't have to be for hire. In any case, if that argument, let me just say, that argument falls. So, do you have any other motions
Definitions
that
fall.
do you have any other motions before the court? I know you're saying that, when we haven't entered, please, this is quite a tangle. Let's take it one thing at a time. Are you saying the court has no jurisdiction?
That's correct. The court has no jurisdiction
And what
because
is-
the officer violated the law.
Okay.
And therefore, from trespasser ab initio is where that comes in.
Okay. And as long as
And I am,
hold on, as long as the officer was acting under color of law in the belief that he was following the law,
Mhm.
and that case law is not
okay, no,
correct, then that doesn't go to jurisdiction. It's not a jurisdictional question. So, now I'm going to ask you if that was the only basis for arguing there's no jurisdiction.
no ma'am, but what is inside the motion is 601-261 on the substance of the
And
court.
that's a whole separate order. I'm just trying to clear up the first thing, jurisdiction.
Okay.
Do you have any other argument with regards to jurisdiction besides the one you just made? That it was ab initio because he impounded the vehicle?
Right.
Do you have any other jurisdiction?
That's what's on, no, I've got all this other to argue, but you said I can only go with what's on the motion, right? That's what she said, I can only go with what's on the.
Let me do this. It's clear to me that you have multiple issues that you want to address with the court.
Multiple.
They have not been received by the court or by the state to respond to.
This one was though, and
Right.
601.
But rather than go forward on one today and on 9 next week,
Well, if I can get it dismissed with this one, then.
well, let me
we
be
may-
clear that you can't.
Well, how come?
You can go
Are
back.
you dead set on ruling against, I mean, why did you say that it's
Your Honor,
not?
if I may.
If this is your jurisdictional one, let me just rule that the court has jurisdiction. I'll rule on that one today. The court has jurisdiction. This one involves
You
other
haven't taken the
issues.
facts of how can you rule on it when you haven't even gone over the facts yet?
Let me put it this way, Mr. Barnes.
Jurisdiction doesn't mean just because I'm in this area that you have jurisdiction. Jurisdiction means you
Legal-
can hear the case itself.
I understand jurisdiction, Mr. Barksdale, I assure you.
Well,
Let me be clear. I have ruled, and you have options if you disagree with my rule. Okay?
I do.
So, with regards to jurisdiction, on the argument that you have now given, I disagree, and your motion or your plea of jurisdiction is denied. And at this time, rather than go forward with your current motion, which has a number of different issues in it that are not clear to me as of yet.
Well, that's why we're here.
And given that you have already made clear that you have a number of other issues that are
Well.
not in here, I'm going to go ahead and reset the motion.
I object, Your Honor.
Do you have a response to the objection?